get started. Bismillah Rahman Rahim. Thank you everyone for joining, those who've joined here and those who will join us on the live stream on social media. This is the first in the series of conversations called the Public Interest, hosted by Public Interest Law Association of Pakistan. The purpose of these conversations is to develop a deeper understanding of the idea of public interest and how it has evolved over a period of time, not just within Pakistan, but outside Pakistan as well, so that both for members of PILAP, but also the general public, we can kind of unpack this idea. We understand that there's a lot of sometimes confusion about what public interest entails, whether this is something done by lawyers or it is something done by the public, and what kind of issues can be addressed and what the law in the country allows and does not allow. So we thought that we will do a series of conversations with people who have been associated with this, who have done public interest both in the litigation sense but also in the advocacy sense. And so in our first of these conversations today, we have somebody who's been associated with this area for quite a while. Dr. Tariq Banuri does not need any introduction. He is the former chairperson of Higher Education Commission. Tariq is a public, a natural resource economist, was trained at University of Peshawar in civil engineering and did his master's then at the Williams College and then PhD at the Harvard University. Has been associated with academia since then, is currently a professor at University of Utah, but has also been associated with institutions in Pakistan, such as setting up of the Water Research Center at Mehran University in Jamshoro, among other things. Tariq has been associated with public interest for a while. He was also the founder of Sustainable Development Policy Institute, and it was in that capacity and in that time that he first got involved with public interest litigation. So welcome, Tariq, to this first conversation. We look forward to hearing from you about your experiences and how you see public interest, how it has performed in the past, and how do you see it doing in the future. Okay, so I think let's get started. So we would love to start with maybe a little bit of an intro. Maybe Tariq, if you could explain what you think is public interest, just for the purpose of our audience. What you think is public interest, what it entails, and what it doesn't entail, and then we're going to talk about how you got started in this and how this whole area sort of got started in Pakistan.
Thank you. And first of all, thank you very much for having me here. Good to be a part of your discussions. I wish all great success to PILAP, and have sat in one of your meetings, and I'm greatly looking forward to working closely with all of you. Public interest, of course, is a well-trodden term. It just means the welfare or well-being of the society as a whole, or the sum of the parts, rather than the individual interests, the interest of individuals, or the interest even of groups. So it has, come not only in law, but even in politics, economics, because in economics and political science, we also advocate policies and actions that benefit the larger community as opposed to individual benefits. So, there is a long background to this. It has come into prominence in such areas as public health, safety, of course, the administration of justice, and now increasingly in environment and human rights. Now, public interest litigation is a particular instrument in the pursuit of the public interest. One can think about other instruments as well, such as policy instruments. But as we'll go later into this, one of the reasons for the proliferation of public interest litigation in Pakistan and in South Asia in general is the increasing perception of the abdication of this responsibility by the state. So the policy dimension, as it has weakened, the public interest litigation dimension has become stronger. I think I'm going to stop there. Maybe there'll be other questions later.
Sure. So, so I think let's get sort of started with the history of public interest litigation in Pakistan, because I think that is quite fascinating. When we met the last time, you talked about this case that you took on while you were at SDPI, that you said was one of the seminal cases of public interest litigation in Pakistan. So, can you talk about this case and what it entailed and what was the result of that?
Um, yeah, let me just say that uh, you know, talk a little bit also about background. I mean, when I have recently looked at the literature on this. By the way, I should explain, I'm not a public interest litigation expert. I have some experience in this because of personal interest, but I think I'm much more of a public interest, a professional who's interested in the public interest through a variety of means, including increasingly litigation. Now, as I look at the literature, there are other examples of what could be called public interest litigation in Pakistan. Oftentimes, the literature cites Benazir Bhutto versus the Federation, 1988, in which she challenged the new restrictions placed on political parties for the 1988 elections. Right, that was one of the first cases. Of course, people say that she was a well-established and relatively wealthy person, therefore it should not count. But nevertheless, it is a case in which the courts first acknowledge the fact that you do not have to be personally aggrieved in order to have the standing to locus standi, as it is called. A more relevant case is the 1988 Darshan Nasi versus the state, which was the brick kiln workers, which had basically, as you know, there's child labor, there's a number of other malpractices in the brick kiln industry, and the union, the people who represented the brick kiln workers, came to the court, and the court again recognized their standing in order to sue. Be that as it may, there is some other history which I will go into it presently. But the case that Athar is referring to is perhaps the most often cited case. It is a seminal case in many respects. It's Shela Zia versus Wabda. It was in PLD in 1994. We filed it in 1992, soon after SDPI was established. I'll give you some background to the case, and then also a little bit more of a background of the provenance of how this sort of came into our understanding that this is one of the ways in which we could do. The case was a very simple one. WAPDA had decided to put a grid station right in the middle of a residential area in Islamabad. And a person who lived there and had two very young nieces, not her own children, but two very young nieces. She had read that grid stations with high frequency electricity has been known in some cases to be associated with cancer, especially for children and for older people. So she became very concerned. She wrote to WAPDA, she wrote to the government, nothing happened. And then through a mutual friend, Madam Shela Zia, who was the head of Aurat Foundation in Islamabad, they came to me and said, you have set up this environmental entity. Can you help? Now, as it turned out, I had recently been exposed to some of the issues in public interest litigation, mainly in neighboring India, which had a much longer history in this regard, and I'll refer to that in a minute. So because of that, I thought, well, why don't we actually think about this as an option, that we go directly to the Supreme Court and we basically ask the Supreme Court to act in this regard. Um, they agreed. I talked with Dr. Pervez Hassan, who's a well-known environmental lawyer, advocate in the Supreme Court, very highly recognized, leading figure in the environmental movement. Was also the chair of the IUCN Environmental Law Commission internationally. So I asked Pervez if he could provide pro bono services to us, and he very happily agreed to do so on the condition that we helped write the brief, etc., because we had all the technical knowledge to do it. So I put together a brief for him, which he approved, and he was very happy with it. And when we went into directly to the Supreme Court, they formed a bench comprising of somebody who was a senior judge, later became, during the course of the trial, became the Chief Justice, Justice Naseem Hassan Shah, and Justice Salim Akhtar. In fact, Justice Salim Akhtar was really a more committed environmentalist. He was also a member of the Environmental Law Commission internationally, and had really a very deep understanding of the of environment-related issues and how it pertained to human rights, etc. Um, so the case went to the Supreme Court, and basically, we it lasted for about 2 years. As I said, it was published in the PLD in 1994. The judges, in their wisdom, and I think that was the right thing to do, they declined to take a position on the technical merits of the case. Because we had provided them some materials, WAPDA had provided them some of the materials, and as a result, they felt that the professional community was divided. They did feel that maybe the weight was not equally balanced, but they decided that it was much more prudent to not make a decision on the merits of the grid station or the location of the grid station. However, they said that it is incumbent on all governmental institutions to weigh the welfare of individuals against potential development benefits, number one. So, this was a kind of a guidance provided directly to institutions. Number two, that in order to ascertain the welfare, that they needed to provide public information and hold public hearings. So they made it a requirement that they hold public hearings. Number three, they invoke the principles of prudence and precaution. Prudence means that when you weigh the welfare against other things, you give a little bit more weight to welfare, and particularly issues of health and life, as opposed to the other, and you try to find a way in which these things could be accommodated. And precaution means that you don't wait for the actual damage to take place before you take action. You undertake research studies, you try to understand, but don't hold back because the research studies are inconclusive. So this was, and they also, in doing so, they made the whole process justiciable, so that if anybody takes actions in this way, this would have this would be a cause for somebody to come to the courts again. As you can see, it was a very prudent and very carefully crafted judgment. This is why it has become a seminal case, and all public interest litigation, as well litigation in relationship to the right to life, to human rights, to environmental rights, all of them see this as a fount through which further analysis and action can take place. So we were very happy that the decision was somewhat in our favor. They had issued a stay order. Unfortunately, I left the country soon thereafter in 97, and after 97, when there was nobody left to kind of go back to the courts, as it were, WAPDA sort of forced through, and also during martial law, when people were a little bit less confident of getting their voices heard. The WAPDA went through and did establish this. So in some sense, ultimately, it was a failure. But the legal principles that they laid down have stood the test of time. So that's basically what I'm going to say there. But as I said, there are other issues. particularly the provenance of PIL cases and the learning that we took from other countries, especially the learning that we took from the Indian Supreme Court. So I can talk about that if you wish.
Yeah. So I just wanted to kind of jump in and say that so this is 1988 or 1992, which you think were the first cases in public interest litigation. So why is this tradition kind of evolving now? So late, about 40 years later, after the creation of Pakistan, and what is the influence of the Indian tradition of public interest litigation in all of this?
Well, you see, the Indian judicial system and ours has the same roots, namely, both of them were established during the colonial period. And in fact have relied on precedents not only during from decisions made during the colonial period, but also from the UK. And increasingly, in after independence, there was references to decisions that took place in other countries, particularly the United States, which had a somewhat different legal tradition. I mean, it had some commonalities with the British tradition, but some differences as well. But the in let's just first go back to India, and that I think will explain a lot about how these things are also being pursued. Uh, in India, the two main individuals who were seen as having pioneered public interest litigation was Justice P. N. Bhagwati, who was the sort of judge of the Supreme Court from 73 to 86, and then Chief Justice of the last 2 years, 85 and 86. And then Justice Krishna Iyer, who also overlapped with Justice Bhagwati around the same time. I think he joined a little bit earlier and left a little bit earlier also. So during their tenure at the Supreme Court, they decided a lot of cases which had public interest, which were later on seen as part of the philosophy of public interest litigation. I can't go into a lot of these cases, but if anybody is interested, Professor Upendra Bakshi, who was a legal scholar in India, I think Vice Chancellor of the University of Delhi at one time. He has a number of articles from the 1980s in this. And Athar, I'd be very happy to share those articles with you. Legal scholars will probably know these already, but I think for others, they might be useful to know. So they started, and they introduced two or three things. Public interest litigation is one of them. But they also, it was a broader concern, and the concern really had to do with the rights of the poor, and kind of a more innovative approach to protecting human rights. So the two principles that they introduced, one was principle of public interest litigation. The other one is closely related. It has not been referred to so often in Pakistan, but you see the principle of absolute and strict liability. When in the individual cases, we look at liability as something in which you have to have the intent to commit a crime, right? The intent is a necessary part of it. But when it comes to regulatory environment, intent alone, intent is in some sense irrelevant. So if you do some damage, even without intending to cause damage, you're still liable. And there are some other this thing. So you can see that that there was a kind of a close relationship between public interest litigation and also the regulatory component, which basically means how do you look at the government. Now, the main thing that I would like to say is that in both cases, in India as well as before I go on, let me just say one thing. In the 1992 or thereabouts, it so happened that our Justice Salim Akhtar, Judge of the Supreme Court, previously Judge of the Sindh High Court, was a member of the IUCN Environmental Law Commission. which is an international body. I think Dr. Pervez Hassan was heading it at that time. So Justice Salim Akhtar was a member. And interestingly, Justice P.N. Bhagwati was also a member. He had retired from the Supreme Court in '86, but he was a member of the Environmental Law Commission because of his work on public interest litigation. And as a result of the endeavors of one very enterprising individual, Mrs. Aban Markar Kabraji, who was the head of IUCN Pakistan at that time. And she basically worked with Salim Akhtar in order to raise the issue of public interest litigation in Pakistan because it was relevant for environmental issues. Salim Akhtar was able to prevail upon Bhagwati to come and visit. I was present at that meeting. It probably took place around 1992. In a galaxy of our jurists. The Chief Justice, Justice Afzal Zulla, could not make it. He had some other commitments, but the previous Chief Justice, Justice Abdul Halim, was there, and 5 or 6 sitting judges of the Supreme Court, 4 of whom became future Chief Justices, namely Justice Salim Akhtar himself, but he did not become Chief Justice, but he was a judge of the Supreme Court. But Naseem Hassan Shah, Saeed Zaman Siddiqui, Ajmal Mia, and one other. I sort of the name will come back to me in a minute. So he was. They were all present. Justice Nasir Aslam Zahid was also there, and he. Sorry, the judge who I was missing is Sajjad Ali Shah, who also became Chief Justice later, as you remember. So P.N. Bhagwati gave a long and really a brilliant lecture on public interest litigation in India, its provenance, the reason why it emerged as a body of law, how it had transformed not only the way of thinking, but also the practice of justice and the protection of human rights in India. Now, as soon after that, Justice Afzal Zulla issued a notification, which basically opened the door to basically opened the locus standi. That means, you could actually file a suit for on behalf of a common interest rather than only if you're the aggrieved party. Now, as we know that earlier on, Benazir Bhutto versus the Federation and the Darshan Nasir versus the state had already taken place, but I don't think, they were in retrospect seen as public interest litigation. At that time, it was still emerging, and Zulla's notification opened the door to this. Justice Nasir Aslam Zahid in Sindh also entertained a number of petitions, and Justice Salim Akhtar, and then later on Naseem Hassan Shah, and then the subsequent Chief Justices were also quite active in this regard. That's one of the reasons why this door got opened in Pakistan. So that is just one thing about how it came to Pakistan. I think P.N. Bhagwati's address in 1992 in Karachi to really the top jurists in the country was a very, very important event, and we sort of draw a lot of inspiration from it. Now, let me say a couple of things about the Indian case also. As I said, the entertainment of public interest lawsuits started taking place in India in the 1970s. And there were a number of things, but when you hear people like P.N. Bhagwati explaining it, his fundamental thing was that, he said, rich people oftentimes have access to justice, poor people don't. Our constitution, and particularly its fundamental rights, one of its main purposes is to protect the weaker and the marginalized segments of society. And if we are unable to do it, then it's a miscarriage of justice. So his question was, how do we make sure that justice is delivered to people for whom it matters the most? So that was where it started from. Now, there are a number of innovations that he introduced. Let me just mention 3 or 4 of them. One is what he called epistolary jurisdiction, in which you didn't have to file a case. You could just write a letter to the judge, right? Epistolary. You could write a letter, or you could even write a letter to the editor, and it got published, and the court would take notice of this. Now, this is something that we've begun to call suo motu jurisdiction. This is a form of suo motu jurisdiction, but basically there's a trigger for it. So he called it epistolary jurisdiction, and it has become quite a common phenomenon. Number two is that they introduce a number of new remedies and enforcement systems. How do you respond to a challenge like this? They issued instructions to the state. They set up social legal commissions to ascertain facts, provide solutions, weigh the solution, provide a menu of solutions, etc. They also used procedural remedies, right? So sometimes this is something that Bakshi called creeping jurisdiction, which means that they would sort of, instead of making an immediate decision, they would issue a series of stay orders, interim orders, which would gradually improve public administration. That means that the case would remain open and the sword would be hanging over the head of the regulatory body. Now, I should say that although a lot of this inspiration, and this is true actually when you actually look at the cases in the 1970s, a lot of the inspiration came from the United States in particular, which had a history of public interest litigation, particularly during the Chief Justice Earl Warren, who I think was there from Roosevelt's time to roughly to Kennedy or Johnson's time. During that period, there were a number of cases that took place which were of a public interest nature. But, scholars actually see the Indian response. And in fact, I've even heard Bhagwati sort of talk about this. Scholars distinguish the Indian response as being different from the American response. The American response is very much consistent with their philosophy of the state, kind of the interest group pluralism, if you can understand that term. The perception is that there are lots of interest groups which are organized. They, in some sense, organize around their own activities, professional bodies of various kinds, NGOs, civic organizations. And this is a way for interest groups, plural interest groups, to engage with the state. Right. So if you're an environmental group, you can engage with the state. If you're labor unions, you engage with the state. And each of those institutions is kind of has its own systems and its own forms of functioning. And and it's also the notion of legal liberalism, right? That this is the purpose of law is to actually enable this democracy to emerge. Now, the perception in India, and definitely so in Pakistan, is that it is not a part of prevailing political philosophy of interest group pluralism. Rather, it is a response to governmental failure. About 30 or 40 years after independence, it became very clear that there was government lawlessness, state repression. Basically, pro-poor policies either did not function or function only for the rich. And there was kind of a need for some kind of social activism in order to protect the common interest, right? So it's a kind of a response to a state failure, as opposed to an element of a political philosophy of multiple interest groups vying for maintaining some kind of an order and creating a sort of a neutral ground for those multiple interest groups to engage with each other, right? That's the US model. The Pakistani or the Indian model is the state failure, which is driving this system. That's, I think, the fundamental thing that you derive from, certainly from the Indian example, and explicitly so when you read their judgments, right? I think Justice Iyer, in one of his Krishna Iyer, in one of his judgments, he says legal dogmas of the quiet past are inadequate to assail the social injustices of the stormy present. Right. So we had a quiet past in which the state was functioning more or less reasonably, but the legal dogmas of that period were basically inadequate. Now you have this thing, it's a kind of a free for all, the stormy present, and we really need a different way of approaching. And in looking at that, I think one can look at 4 or 5 different principles, which I can just quickly go over. One is that the courts increasingly have started taking fundamental rights, started focusing on fundamental rights. So, public interest litigation has become the vehicle through which fundamental rights of the constitutions are being both protected and interpreted. There's a kind of um, shall we put it this way, that the attempt has been to interpret the fundamental rights of the Constitution more broadly, right? In the Shaila Zia versus Bobda case, and earlier on in some of the Indian cases, they said that the right to life includes the right to a clean environment, right? Includes the right to health. Because if you're not healthy, your right to life is being deprived. So they expanded the notion of the right to life. In an Indian case, the right to free speech was expanded to include the right to travel. That if you're not allowed to travel, then it's preventing your free speech, right? So it's an expansive understanding. The second thing is that they, in both India and Pakistan, that they have actually not only begun to focus on fundamental rights, but on what the German legal scholar Dieter Conrad called the basic structure of the Constitution, right? So that means that even constitutional amendments cannot undermine fundamental rights and cannot undermine the basic structure of the Constitution. So this is an interpretation that emerges once this process starting. Number three, another principle is that sometimes the common interest of a large number of groups are large, but the individual benefits may be small. So that means that the legal recourse is not available to them because the cost of legal proceedings is too high, even though the total benefits are very large. So it's a way of protecting the totality as opposed to the individual benefits. One thing, and this is why I mentioned the absolute liability issue also, is that courts have begun to increasingly interpret the difference between fair play and foul play. That means when a state acts through fair play, they tend to take a more restrictive interpretation of the law. That means they will not interfere. But if they suspect foul play, then they are likely to take a more expanded interpretation of the law and then come in and protect this. So, I think that, this entire process, this is how it has been. Now, one last point I'll say, and then I'll stop. And that is that neither in India nor in Pakistan has it played out in the way that the earlier advocates, including people like Bhagwati and Iyer and Justice Salim Akhtar and Naseem Hasan Shah, that they imagined it would play out. It has actually, the focus has shifted from fundamental rights to individual rights. So individual rights are being protected, especially of elite people, are being protected in the guise of broader human rights. The focus on poor has pretty much gone in both countries. The focus of the interpretation of the Constitution has also become a little bit less transparent as we have gone along. So I think that even though I feel that it was a major step forward in terms of our dealing with our state failure, and also in terms of taking our human rights seriously, it has actually reached a point where we need to sort of think carefully about how it can be pursued in the future. Thank you.
Great,
Sorry,
thank you,
it was a
Tariq.
very
No, no,
long.
no, very, I think very detailed and interesting. If possible, I'd like you to kind of unpack a couple of things. One is this idea of sort of poor versus rich. If the idea is to provide legal recourse to the poorer people who do not have legal recourse otherwise, why isn't legal clinics and subsidization of filing petitions the better mechanism for doing that? Uh, and the other idea is, obviously, I mean, you kind of alluded to it a little bit. I mean, I feel the fundamental idea in public interest litigation is that the person or the entity that is filing the litigation is not the not the major beneficiary of the litigation. It's the public, it's at large, which is the beneficiary, right? So is that a proper construction? And if so, then this poor versus rich idea is does that kind of go with that? And the other thing that I want you to kind of comment on is this idea that you and I discussed that it was originally assumed that the state was responsible for protecting the rights of people, and now suddenly the state is not seen as responsible anymore, and so there is this need for other entities to come in and try to force the state to uphold its responsibility.
Okay. Now, the first one of legal clinics, obviously that is a very important innovation. Now, interestingly, in the US as well as in India, the creation of legal clinics was the result of public interest litigation for on behalf of the poor,
Mhm.
right? So that means public interest litigation was the way through which it got done. It didn't happen as normal part of executive action. It was the judiciary which enforced these things. But having said that, that is not the only option. I gave the example of the triviality of individual benefits versus the magnitude, potential magnitude of the collective benefits. Now, let us say that there are 100 people who are all aggrieved, and each one of them has, let's say, a benefit of maybe 1 lakh rupees if something got reversed. Now, together they have a benefit of 1 crore rupees, which means together they could actually hire a lawyer and protect themselves. But individually, it doesn't make sense because the legal cost would far outweigh the potential benefits that they would do. Right. So, public benefits are also a way in which you do the aggregation problem, and this is very much explicit in the judgment. More generally, I think this is a way in which, because of the combination with the sort of the epistolary and other forms of, suo motu jurisdiction, that this is the way in which you're kind of shortcutting, reducing their costs, and enabling the justice to actually get to the doors of the poor rather than wait for the poor to come to you. Now, the thing that sort of, and this is most explicitly in Bhagavati's writings, also in Krishna Iyer's writings. The thing about them is that they saw the focus on the poor as one of the objectives and justifications of public interest litigation. But they also saw it as kind of strategically the most important. That is the where you enter. And in fact, in some cases, they would use it as a test to determine whether something was worthy of judicial intervention or not. Right. So they would say that justice will fail if we do not take action in this case, and justice will fail would happen in the vast majority of the cases where the poor were involved. I think this is also related to the other things about public benefits versus poor benefits. I think the general consideration is that the the public interest litigation should operate where it is welfare of all or of a significant majority, as opposed to the welfare of one or two individuals. Increasingly, we have seen that public interest litigation in Pakistan is being used for very narrow parochial ends. That means, you want to benefit a particular politician, you want to benefit a particular powerful person, and you use the guise of public interest litigation to help them. And that means that there has been a kind of a reversal in the overall conception of public interest litigation. As I'm saying this, I'm also feeling that in our group today, there should be legal scholars who might be encouraged by our conversation today to do what Upendra Bakshi did in India, to actually look at the history of public interest litigation, see what the origins of this is, see what the principles are, and see how, in some cases, it has kind of reversed itself as it was proceeded, and therefore also offered, sort of derived some principles for future action. I'll suggest a few, but I think these are some things which require people who are legal scholars, as opposed to myself, basically studies governance. Sorry, your last question was
Was regarding states abdication of its responsibility to citizen rights, and why then obviously public interest became.
yeah, I mean, you see, I mean, if you go back in history, for instance, if you read Hegel, in Hegel, when he says state and civil society, it's very clear that he sees the state as kind of the perfection of society, right? It represents the larger ideals of society. And the civil society he sees this as individual interests. And so it is, in some sense, a more profane domain as compared to the state, which is a more sacred domain. Now, those of us sitting in the 21st century now look back and they should be allowed a smile, because today our perception is exactly the opposite. The state is the profane side. It is no longer the protection of public interest. It no longer represents the public interest in any shape or form. It's actually a kind of an elite mafia, which basically take turns to loot the common individual. And in some sense, what has happened is that a lot of organizations like PILAP, like others, NGO, STPI, have actually taken on the mantle of the pure, the sacred part of the collective action. Right. So this failure of the state is, in some sense, one of the motivations for this. I think what happened in South Asia, India, Pakistan, Bangladesh, all is that the some innovative jurists understood that the state had basically begun to demonstrate symptoms of failure, and they felt that administration of justice was impossible unless this could also be addressed. And so, in a number of landmark cases, they began to enter into areas which the judiciary had until then refrained from entering. Right. So, this is essentially the direction in which it has taken place. As the crisis of the state in our country certainly, but also perhaps less so, but definitely quite pronounced in our neighboring countries, as the crisis of the state has progressed, this domain has become increasingly important. Now, the real problem that is happening is that the state is powerful enough to be able to hijack anything that is done to tame it. So, I mean, our constitution establishes a number of mechanisms to tame the state, right? To protect us against the criminality and the excesses of the state, right? That is really the purpose of the constitution. Nothing else, that the governments should be limited in their capacity for mischief and folly. But every institution that is set up, they try to capture it. So the state has captured a number of institutions. I will not go into details, but even this instrument, which was meant to tame the state, has actually, in part, become a weapon in the hands of the states. And is oftentimes being used against political opponents and even against the common public. And I think one of the roles of right-thinking activists in our society is not only to act in this area, therefore to work to protect people's rights, but also to try to find ways in which this instrument, which is meant to protect the collective interest, the interest of the poor, the interest of the weak, the marginalized, from being hijacked by those very elements against whom it was crafted in the first place. So that is also our responsibility. It's a responsibility that can be done through collective action, through protest, but also increasingly through research and writing, and also holding events like this.
So I want to kind of talk a little bit about abuses of the public interest litigation. And I remember talking to late Dr. Tariq Hassan. He was one of the founding members of PILAP, and I was having a chat with him about public interest, and he felt, after having set up PILAP, that he was very disillusioned by how the public interest litigation tradition in Pakistan has unfolded. Uh, so, do you have any sort of comments, ideas on how why it has been the case? Particularly, I think he was very concerned about the frivolous litigation by lawyers and others to try to as you said, uh, give benefit to the elite and stuff. So any comments on that and how that can be improved?
Well, certainly that is a popular perception, and I think this is one of the reasons why, in the conflict between the judiciary and the executive seems to have the upper hand at this stage, because there was a perception that while the state itself was not only profane but self-interested, self-motivated, that the same accusation could also be leveled against the judiciary, especially in the exercise of this jurisdiction. I mean, I know, for instance, of cases in which some individual who's well connected would, I mean, I don't know if I don't want to refer to an individual case, but let me just say that when I was at HEC, um, we used to hold an exam for entrance to, I think it was either for law or for graduate school. And, hundreds of thousands of people take it. And basically, it was administered in all in all capitals, right? So Islamabad, Peshawar, Lahore, Karachi, Quetta. And then somebody from one of the other areas who probably was well connected went to the High Court under a public interest litigation guise and said that I want this to be held in their city, which was not one of the cities where it was traditionally located. Now, this was like 2 days before the exam was held. Roll numbers had been sent out, hundreds of thousands of people who had all prepared, who were ready to come for the exam. And 2 days before the court issues a stay order, says you can't hold the exam. Now, if you actually weigh the benefits of the collectivity as opposed to the individual, you can tell that the stay order was actually violating the rights of several 100,000 people as opposed to the rights of one person. But that one person was well connected, and a more prudent judge would basically have held the institution to account for future these things and given instructions and so forth, but also have been cognizant of the rights of the people who were not able to approach them. So, I mean, there are numerous examples of this type. One individual goes in. There are lots of cases. Every person who gets appointed to a position, any kind of a sensitive position, or if they have enemies, which lots of people do, they have public interest cases filed against them. And throughout their tenure, they keep fighting them. Most of them are frivolous. The courts entertain them just because there are no guidelines, and oftentimes they're just meant to protect one or two people, or not even to protect. Sometimes they're just meant to create turmoil. And I think it would be useful if the courts were to recognize that these kind of things are happening and perhaps provide some mechanism in which the wheat could be sifted from the chaff. But at this moment, one doesn't have this feeling. And in fact, the larger perception is that the incidents which are kind of broadly looked down upon have proliferated. They're actually much more common than perhaps is desired. I think I'll leave it at that.
Yeah,
I'm treading on somewhat difficult terrain, and I don't
sure.
want to step beyond what my own expertise is.
Sure. So now let's talk to the case that you were the subject of, which was uh, the case that was filed when you were removed from Higher Education Commission. You ultimately ended up winning the case, although the effect of that win was basically nullified because it took so much time for for the decision to be announced. So can you talk a little bit about that case and how?
Yeah, I mean, you see, the issue there was the following: that the background was there was somebody close to the government who basically wanted money, access to resources, and was very unhappy that somebody like me was standing in the way. As soon as that government got, through the Senate elections, they got a reasonable chance of controlling the Senate, they issued really a kind of a laughable notification to uh, to change the law so that they could fire me. Right? I mean, so I was the head of a statutory body, regulatory body, with given protected tenure, who could not be removed except for gross misconduct, etc., etc. And instead of actually doing that, or attempting to file any charges of that type, they just changed the law and said because there is knowledge economy proceed all over the world, therefore it is important to um, uh, sort of restructure the higher education sector. And in order to do that, the tenure of the chairman is reduced from 4 years to 2 years, and this will apply to the existing person, right? So they had to do all of those things. And the justification was such that when it was read out in the court, even the judges started laughing. Like, how could you write something like this? Now, the thing is that my perception of it was that, really it didn't matter whether I was fired or not. But what they had done was they had taken a hatchet to the autonomy of an institution. I mean, already we felt that no autonomous institution in the country is safe. And, a lot of institutions, universities, hospitals, sort of regulatory bodies, etc., were subject to massive interference. And here was an institution which I thought was meant to be both not only autonomous, but also a way of protecting the other institutions in its orbit. And they had basically taken a hatchet to it, saying, you know, uh, it's in theory this is autonomous, but in practice, if you do something against us, we will get rid of you, right? So the notion of fixed tenure as a way of protecting the decisions of the institution was totally undermined. So my interest was not to fight the fact that they had removed me. My interest was to say, look, the autonomy of institutions, not only regulatory institutions, but all the autonomy of institutions that had some kind of a professional remit, is important for the well functioning of the society. The more the government interferes on political grounds, the more not only it weakens them, it ends up undermining the very purpose for which those institutions are established. The delivery of those services gets undermined. We know how governments interfere in universities, it undermines the universities. We know how governments interfere in all sorts of appointment matters at various regulatory and other borders. We know that it undermines all of those. None of those are really properly functioning organizations. The judiciary also was, I think there was a big onslaught against the judiciary. They protected themselves. That onslaught has begun again. And so with each one of these things, they are weakened. So my purpose in all of this was to ask a number of people whether they felt that this is something that would be a matter of public interest, and they would go to court for it. So we got more than 100 people willing to go to court. Because of practical matters, I think we only got 20 names, but many more names were willing to sign on to this thing. It was Musharraf Zaidi versus the Federation of Pakistan. And eventually, the High Court ruled that this entire order and everything was illegal because they did not actually go into the grounds themselves. That I mean, look, you can't do this with a laughable justification, etc. But they basically said that the manner in which it was done was malified, and therefore they overturned it. Now, but they did not undo the legislation. I think what we were hoping is that they would undo the legislation and declare it to be contrary to the human rights which are guaranteed in the Constitution. They did not do it for reasons that are best known to them. But nevertheless, it was an important innovation as far as I'm concerned. Um, Now, my sense that what I draw from this is the following. I think that at some stage, the judiciary as well as the common public have to recognize that a state functions well when autonomous institutions can operate freely within their own domain, or have a very high degree of autonomy, or almost complete autonomy, but only subject to accountability through mechanisms that are well known, like auditing processes and some kind of KPIs to which they will adhere. I mean, I give the example of universities. The government should get out of the universities, basically make the universities autonomous and hold them accountable only for their outcomes rather than for internal hiring and firing and so on and so forth. Now, I think if the courts do not recognize it, and if our activist community does not recognize it, that we need to create this network of autonomous institutions and protect them. Until this is recognized, we will not move towards a more harmonious and a more well-functioning society. And I think as we begin to move in this direction, this case can become a landmark case in the direction that we move.
So Tariq, just to play the devil's advocate, I think the government's position, may be wrong in this particular instance, was that we are the government. It is our right to implement policy, and this idea of autonomy of HEC is not letting us to implement the policy, right? So there is a policy jurisdiction of the government, and obviously there is autonomy of the HEC, and in this particular case they were in some kind of a clash. So if there are a whole bunch of autonomous entities within the state, then what becomes the role of the government? How
Well,
does government implement policy?
no, I mean,
I
the
mean,
thing is
I
that,
get the idea of autonomy for Election Commission of Pakistan, for example, that it has to be above the government, right? But for other bodies which are below the government and part of the policy instruments of the government, how does the government implement policy there?
yeah, I mean, you see, the thing is, policy is always the art of the possible. You really need to understand, how to use policy in particular. In many cases, I mean, the word policy is not very well understood in Pakistan. In fact, if you look at a lot of the so-called policies that government puts out from time to time, they're laughable. They really don't know what policy is. In most cases, not having a policy is actually the best thing that you can do. Even in other cases, you have to weigh the larger interest against individual interest. You also have to look at the downsides of particular interventions and ask how these things could be done, can better be done. Now, so you see, you always realize that policy is not like a blunt instrument which you can then, almost like a bull in a china shop kind of a thing that you run through it. You actually have to use it carefully within an environment that is given to you. Now, the thing that we would like to see is that this is an environment in which the trains run on time, regardless of which government is in power.
Mm-hmm.
Now, we would like the to use this example, the railway then to be an autonomous institution that is responsible for its own functioning so that it can professionalize itself, be able to deliver. And the way the government would control it through some kind of a budgetary process, right? It's not a blunt instrument in which you say, okay, move this engineer from Sakhar to Quetta, or to, sort of give special preference to this person who's asking for a favor, etc., etc. That's not the way to do it. You actually do it either through some kind of a budgetary thing or through, through normal auditing processes and through KPIs. Now, so I mean, and these are very well-known systems through which governments interfere and control these things. In our case, the government has taken the view that the government, the political government itself, each individual, each incoming political government has the right to interfere right down to the lowest level in every institution. That means no institution is considered to be autonomous. In fact, if I could say that, the only remaining institution which is autonomous in the country is the military. Right? You don't expect the prime minister to pick up the phone and say, "Is colonel ko transfer karke वहां लगा दें, वो इस वक्त मुल्तान में है तो उसको वहां पे लगा दें या इसको प्रमोट कर दें एंड ऑल दैट. We people understand that this is not a done thing, but they also, they don't understand that you should not be doing this in railways either, that you should not be doing it in HEC or universities कि इसको hire कर लो, उसको fire कर लो, इसको promote कर दो, etc. These things happen all the time. So we need to create an institution in which this autonomy becomes one of the principles, together with accountability, in which we then ask what kind of accountability mechanisms are consistent with an autonomous organization, right? Because we haven't had autonomy, we haven't been able to set up accountability mechanisms. The only thing that we have been able to set up are kind of micromanagement and sporadic intervention, right? Or almost continuous intervention. No, and we understand that the result of it is that our universities have failed, our hospitals have failed, our railway systems have failed, our PIA has failed. Everything that the government basically begins to interfere, it fails. We used to run properly, efficiently. All of a sudden, we realize we can't run any damn thing, right? When I say that this government failure began to be recognized in the 70s and 80s, you realize that many institutions which were working perfectly before then, profitably, example for others, are now all failures. Every single institution that you can think of, everything is a failure. And one of the reasons is that none of these institutions has the space in which to develop itself and to begin to deliver the projects that we want. So I, I am of the view that we need a network of independent autonomous institutions. We also need to put our heads together. I have some ideas on this. You might have some ideas. We need to put together our heads in order to design proper accountability systems which are consistent with the autonomy of these institutions, as opposed to interventionist accountability system. I will leave this at that. But if there are questions, we can go back into it.
Yeah, so I'm conscious of time. I think we are almost running to our allotted hour. Uh, but one sort of final question: if the purpose of the public interest litigation is to hold the government to account, then the instruments for holding the government to account are also very limited. I mean, as is the case currently, uh, even if the courts rule against the government can decide not to implement their ruling. I mean, this is happening not just in Pakistan but in America and elsewhere as well. Now, one thing that I feel that has been missing in Pakistan, and you see this America in places like America, is that courts can actually uh, assign damages that government bodies have to pay because they've caused harm to people through their action. That is something that is missing in Pakistan, and I feel that something like that, if implemented, would, because at the end of the day, all of this depends on people's good intentions, right? And if those good intentions are missing, and as we've been talking about, we are literally talking about the government as if it is the villain in this whole picture, right? And that's the villain that we have to stop. So we need strong instruments to make them stop, right? In the US, even when courts have made decisions that have harmed people, they've had to pay penalty, and that puts a very strong disincentive on the bureaucrat to make sure that he does not commit excesses. So do you feel that something like that, or some other suggestions that you might have to enable this public interest litigation to be more effective in places like Pakistan?
Let me say three things. Number one, the state itself. Number two, the remedies of this pecuniary remedy, right? And number three, kind of the broader principle of the remedies themselves. First thing we have to recognize is that the state, that we tend to have taken a kind of a moral view of the state, good and bad, etc. I personally don't take that view. Um, but I do recognize that the state is prone to criminality.
Mhm.
The state is prone to criminality, right? It attracts criminal elements. And there are ways in which the state, no matter how you structure it, whether it is democratic, bureaucratic, there are ways in which it will overstep those boundaries. And in all of the systems that the modern society has set up, are systems that are meant to tame the state. The Constitution itself, its primary purpose is to protect you against the state. I mean, if you think about it, and the First Amendment to the U.S. Constitution, the Bill of Rights, the Bill of Rights is really a way of protecting you against the state. Right? And in every constitution that you look at, you will find some kind of a Bill of Rights, fundamental rights, and they are protecting you against the state. Why? Because the state is prone to criminality. So, number one, we want to protect people against it. Number two, we want to make sure that the state itself recognizes that there are borders beyond which it should not go, to generally place a limit on its capacity for mischief and folly. Now, that's kind of the broader principle that I want to do. The second thing is that even if you think about public interest litigation, in some sense, it is what we in economics call a second best solution. Right? The first best solution is that you have a responsible state. Right? Because we cannot have a responsible state, therefore, we have now resorted to public interest litigation. If you ask me what I would want, what do I dream about Pakistan? I dream that we have a state that is responsible, that delivers services, that recognizes the public interest, and becomes the protector and the guardian of the public interest. In that case, the judiciary would have a much more limited role to play. They would still do public interest litigation, but their role would get greatly confined because the state itself would end up taking the picking up the gauntlet. Our state has actually abdicated that responsibility, right? Because they are so concerned about their private interests that they really cannot talk about the public interest anymore. So ideally, this is the direction in which we'd like to go. Now, the third thing I want to say is the following: that if you look at public interest litigation, the entire process, as I've tried to map out to you, this is a process in which the courts have tried to apply their mind, not only in terms of what are the areas in which to intervene. That means expand the area of intervention, bring in liberalize locus standi, liberalize ways in which we are willing to interfere, but also expand the the menu of remedies and enforcement strategies, right? They've constantly been thinking, okay, set up a commission here, give directions to this thing, or this thing that Bakshi calls creeping jurisdiction. That means, don't decide a case immediately. Keep the sword hanging over their heads, keep on issuing stay orders and trying to get the institution to move towards a more desirable direction. Now, in this innovative expansion, one of the instruments that is possible is a financial and pecuniary instrument, right? It has been used with great effect in the United States. It has not been used significantly in any of our cases, and it is quite possible that one of our enterprising judges might see that as a potential way of moving forward, right? But I do want to warn you that the real problem is elsewhere. The real problem is not in the remedies themselves, right? The remedies have been expanding and may expand even more. The real problem is that number one, we have a failed state or a failing state, and number two, we have a potential for capture of any institution that begins to challenge. So the public interest litigation process also has been captured in some respect, right? So its ability to deliver on its original promise of protecting the poor, protecting common interests, etc., has been somewhat circumscribed. So we need to think about the larger political and even the intellectual challenge that poses for us. A particular instrument is not going to solve any of the problem, right? It will solve it for a short time until people learn a way of trying to tame it.
Thank you. So I'll just take one question from the chat window. So somebody said, not sure if it is relevant, but what are the first steps for an uninitiated individual like myself who truly cares about the country and the public interest? What should I do? I see Dr. Tariq's journey. How can we follow in his footsteps? I would say, first of all, join PILAP. Tariq, what are your thoughts on somebody who wants to take up this fight of public interest and follow your footsteps?
Well, first of all, I welcome them as a comrade. Not You can't follow my footsteps because the environment in which we were taking action is now gone. You're in your own environment, and you have to kind of find ways to move forward. I do think that looking at the past actually helps. You look at see how other people reacted. Some of it may be relevant for you, some of it might not be relevant for you. Find the one that is relevant. Collective action, finding other people who are working with you, using the courts, they are using the media, using your writing, using your voice. All of these are vehicles for protection of the common interest and advancing what we believe to the larger goals for which our country was established. And I wish all the best to the gentleman or the lady who asked that question.
Great. Thank you very much, Tariq, for this very enlightening conversation. Really, really impressed with all that you have been a part of and have been able to achieve. And I think sometimes it becomes really challenging in the environment that we are in to even continue this fight, because if nothing works, if the legal system doesn't work, then what is the remedy that is available to people? But I think we all believe that an entity like PILAP, and there are sort of multiple other entities like these, they need to be strengthened so that someday we will be able to get back to, as you said, the responsible state in Pakistan, and be able to create a country that we are all proud of. Really, really appreciate your time, and inshallah we will continue this conversation, and would love to see everybody back again sometime. Take care.
Thank you.